So we are group 15. Our group will be presenting on the topic of undue influence in Malaysian and English position. These are the content that we will be presenting in the video. The concept of undue influence was established to address situation in which a contract was formed due to external pressure. Although those pressure did not reach the level of duress, undue influence may manifest when one party manipulates a pre-existing relationship with the other party in order to secure an unjust advantage. In accordance with Section 10, subsection 1 of the CA 1950, any agreement can be considered as a contract if they are entered into by a party who possesses the legal capacity to contract. They involve a valid consideration and lawful objective, and even if they are not explicitly declared or void. Consent, as defined in Section 13 of the CA 1950, is established when two or more individuals mutually agree on the same matter in consistent manners. Section 14, subsection B of the CA 1950 elaborates on the concept of pre-consent, stating that consent is deemed to be voluntary when it is not induced by the undue influence. According to Section 16, subsection of the Contract Act, undue influence occurs when one party has the ability to dominate the will of another due to the relationship and exploit the power to gain an unfair advantage. There exists a limited number of essential components that must be present for the establishment of the undue influence. Primarily, the dependent must occupy a position of superiority in their association with the planet. Secondly, the dependent must exploit this authoritative position to procure the transaction in question. Finally, the transaction itself must be deemed unjust or inequitable toward the plaintiff. In accordance with Section 16, subsection 2 of the Contract Act 1950, the provision outlines specific scenarios in which a court may determine that an individual possesses the ability to extract control over another person's will. This scenario includes situations where an individual holds a genuine or a perceived authority over the party, where a fiduciary relationship exists between the two parties, or where a contract is entered into with a person whose mental capacity is impaired due to age, illness, or physical or mental distress. In the context of Malaysian law, Section 16, subsection 3 operates in a manner resembling the English legal principle whereby the responsibility to prove the absence of undue influence falls upon the influencer. However, the clear differentiation between actual undue influence and presumed undue influence, a characteristic of English law, is not uniformly applied within Section 16 of the Malaysian Contract Act. Instead, the Malaysian legislation primarily relies on the concept of the interrelationship between the parties as a crucial determinant. According to Section 20 of the Contract Act, any contract that involves the presence of undue influence can be rendered voidable at the discretion of the party whose consent was influenced. For the English position in Bank of Credit and Commerce International and Body 1990, the Court of Appeal identified three different categories of undue influence. Class 1. Actual undue influence. To establish the existence of actual undue influence, it is necessary to provide evidence demonstrating that the contract in question was entered into due to the exertion of such influence. Examples of such influence may encompass actions such as employing threat to terminate a relationship or persistently pressure a party who initially declined consent until eventually acquires. Class 2. A presumed undue influence. In this court, it is not necessary to provide concrete evidence of the exertion of improper influence. Nevertheless, it is essential to establish a legal relationship that would create a presumption of undue influence. Such a parent-child and demonstrate that the transaction cannot be readily explained by the nature of their relationship. Class 2B, presumption under undue influence. If a relationship is present that does not automatically create a presumption under Class 2A, but where it can be proven that one person places their trust and confidence in another, a presumption of undue influence may still arise, for example, in case involving an employee and employer or cohabiting individuals.
Thereby, the plaintiff regrets entering into the contract and now wishes to revoke it. To do so, the contract must be voidable in the first place. Section 20 of the Contracts Act 1950 will be applied as the remedy for the rescission. In Saw Gabriel against Chong Yu Meng and others 1989, Edgar Joseph Justice referred to the precursor case of Pusat Turai against Kanapa Chitya and others 1990, where Lord Shaw indicated that the Indian Contract and English law are identical when it comes to the notion of undue influence. According to Gopal Sriram JCA, in the case of Tengku Abdullah Ibni Sultan Abu Bakar against Muhammad Latif bin Sham Muhammad and another appeals 1996, Section 16 has been interpreted broadly in accordance with the equitable nature of the doctrine of undue influence while taking into account the Malaysian context. Under Section 16, Clause 1, there are two elements that must be satisfied. The first element is that there must be a relationship between the parties which enables one to dominate the will of another. Will Chandra and Devi falls under the fiduciary relationship in section 16 clause 2 in the Malaysian case of public finance were held against Lee Rubber Factory in 1994. Edgar Joseph states that a presumption of undue influence may arise in some relationship, such as those between a parent and child, a person in local parentage and his charge, guardian and ward, doctor and patient, solicitor and client, spiritual advisor and congressional member, man and fiancé, and trustee and beneficiary. However, the law regarding undue influence does not consider a husband and wife as in a fiduciary relationship. When marriage brings affection and confidence, it does not constitute undue influence. In this situation, it is important to determine whether the party seeking to enforce the contract had actual or constructive knowledge of the undue influence. The English case of Barclays Bank against O'Brien, which will be discussed below, is cited with approval. This case, therefore, will not fall under section 16 clause 2 of the Contract Act 1950. Shaw states that undue influence in legal proceeding is often misunderstood as simply as a result of the parties' nature dependence on each other for advice and the other dominating the will of the first. It must be proven that the person in a position of domination had used it to gain an unfair advantage and cause harm to the person relying on their authority or aid. If the relationship of influence is established and the bargain is with the influencer and unconscionable, the person in a position to use their dominating power must affirmatively prove that no domination was practiced to bring about the transaction. Therefore, whenever there is a relationship between the parties, it must generally be determined whether that relationship allowed one of the parties to have the position to dominate the other's will. To put it briefly, it must be determined whether one of the parties have some ascendancy or position of advantage over the other. Chandra's main purpose in this situation is to acquire additional capital to support his business. Where he persuaded Devi to use her large house as security for a loan he was negotiating. Obviously, he is taking advantage of this position. Devi is not acting on her free will when her original intent is to start a business, but was dominated by Chandra to use the large house as a security. The second element is that the dominant person did use their position to obtain an unfair advantage over the other. Since one party benefits more from the terms of the contract than the other, there must be a substantive unfairness that results from this. In the case of Saw Gabriel against Chong Yu Wei and others 1989, Edgar Joseph states that the principle of equitable relief in transaction is based on the prevention of victimization by one party, not the inequality of bargaining power. Courts only grant equitable relief in exceptional circumstances, even if a bargain appears harsh, unless it is demonstrated that the transaction was to the manifest disadvantage of the person subjected to the dominating influence. One promised Devi a share of the company's profit, which seems unfair as their profit does not equal the value of the large house left to her by her father. She may also lose her house if Chandra's business fails. Chandra's needs for more funding after receiving his first loan suggests that the company is in difficulties and may not be able to provide the promised profit. Overall, it seems to be that the disadvantage outweighs the advantage, indicating an undue influence between Chandra and Devi. Pursuant to Section 16, Clause 3, Clause A of the Contracts Act, once a position to dominate the will has been established, the burden of proof then shifts to the person accused of exerting undue influence to prove that he did not do so. Therefore, the burden of proof now shifts to Chandra. Chong Siu Fai said in Brilliant Credit and Leasing Sanjay Berhad against Kim Young Timber Sanjay Berhad and 7 others 1991 that to free himself from complying with an agreement, a party must prove that the bargain of its terms were unfair and unconscionable. This is not just about proving that this agreement was unreasonable, but also that one party imposed an objectionable term in a morally reprehensible manner, affecting their conscience of procuring the bargain through unfair means. Despite the term unconscionable appearing in Section 16, Clause 3 of the Contracts Act 1950, courts in Malaysia are not inclined to define or determine what constitutes an unconscionable transaction. One way to demonstrate that the other party acted of his own free will when the presumption of undue influence has been raised is to demonstrate that legal advice was sought before the alleged document was signed by the complainant. The Privy Council case Tinchi Noria against Shaikh Ali bin Omar 1929 demonstrates that, however, the mere fact that legal advice was sought does not automatically rebut any claim of undue influence. Even though Chandra's lawyer had a short private meeting, in this particular case, the risks involved in using her house as security were not disclosed by the lawyer. The presumption of undue influence is not rebutted as a result. Devi will be able to set aside the bank's security contract. However, the loan contract between Chandra and the bank cannot be set aside.
Now I'll be talking about the dispute between Chandran and Devi and the bank in the UK position. The main difference with the Malaysian position is that English law has classified undue influence into 3 classes, which was explained previously in the introduction. The situation above falls under presumed undue influence rather than actual undue influence because there is nothing that is very obvious on the face that she had been unduly influenced. There are 3 stages that need to be proven in order to successfully rescind a contract for presumed undue influence. First, the innocent party must prove that either there is a pre-existing relationship of a special kind or pre-existing relationship of trust and confidence between the parties, which class would husband and wife relationship falls under. In the case of Royal Bank of Scotland and Ettrick, Lord Nicholas' speech lists out some examples for special relationship such as parent-child, guardian-ward, but explicitly excluded husband and wife on the ground that there is nothing unusual or strange in a wife from motives of affection or for other reasons conferring substantial financial benefits on the husband. It has never been accepted that a relationship of husband and wife leads to a presumption of undue influence. Influence may be as no one is free from influence but not undue. Also, in public banks, it's settled that although there is no class 2A presumption of undue influence as between husband and wife, it should be emphasized that in any particular case, a wife may well be able to demonstrate that de facto she did leave decision on financial affairs to her husband, thereby bringing herself within class 2B. The relationship between husband and wife in the particular case was such that the wife reposed confidence and trust in her husband in relation to their financial affairs, and therefore undue influence is to be presumed. Thus, in those cases, a presumption of undue influence within class 2B can be established solely from this proof of such trust and confidence without proof of actual undue influence. Thus, David and Chandra will fall under class 2B undue influence. Secondly, there must be something about the transaction which calls for an explanation by the dominant party. There arises a rebuttable presumption of undue influence if the answer is confirmative. Per Lord Nicholas, something more is needed before the law reverses the burden of proof, something which calls for an explanation. When that something more is present, the greater the disadvantage to the vulnerable person, the more cogent must be the explanation before the presumption could be rebutted. Similarly, in the case of Alka and Skinner, the plaintiff executed a will leaving all her property to the defendant, and also she transferred substantial sums of money and railway stock that she had inherited to the defendant. The huge amount of transaction was something that needed to be called for an explanation. Applying for Debbie, there exists a need to call for an explanation because she used her big house as a security for the loan of Chandran with the bank. There is a risk of losing her large house if Chandran is unable to pay back the loan. Thirdly, in the case of presumed undue influence, generally will consist of the defendant's attempt to rebut the interference of undue influence that has arisen from proof by the claimant of the existence of relationship and transaction which requires explanation. After Debbie has established that there is a rebuttable presumption of undue influence, now the burden shifts to Chandran to rebut the presumption. The law of contract cited that the presumption is rebutted if the party benefiting from the transaction shows that the transaction was the free exercise of the independent will. Debbie is not exercising her own free will when her initial intention was to use the large house to start off with some business, but being persuaded by Chandran to use the house for a loan security purposes. Also, suggested in the case of Royal Bank of Scotland, another way to rebut the presumption is to show that the victim had independent advice from a third party before entering into a transaction. However, getting independent advices does not necessarily rebut the presumption, but just one of the pieces of evidence to be taken into account. In order for Debbie to rescind the contract with the bank, she must prove that either Chandra was acting as the bank agent or the bank had knowledge or actual notice or constructive notice of the undue influence exerted by Chandra. In the case of CIBC mortgages, although the wife succeeded in establishing actual undue influence by the husband, the loan agreement between her and the bank remained unaffected because the husband was not acting as CIBC agent. CIBC has no actual notice of the undue influence, nor CIBC could be said to have constructive notice of husband undue influence by being put on inquiry because of the fact that the charge stated the purpose of the loan was to refinance the matrimonial house to enable the husband and wife to repurchase another house. There was nothing to indicate CIBC that the transaction was anything other than a normal advance to a husband and wife for their joint benefit. Constructive notice applies when the party did not have knowledge or actual notice of the particular circumstances, but because, having been put on inquiry, the party turned a blind eye by failing to make an inquiry or he was negligent in the inquiry made. Applying to the above situation, when the manager advised Debbie to look for a private meeting with a lawyer before she commits herself, the bank may be regarded to have received constructive notice. Now, the burden shifts to the bank to prove that they had taken all reasonable steps when dealing with the sureties. In the case of Barclays Banks, Lord Browning Wilkinson provided some guidelines as to whether the bank had taken all reasonable steps. The first one being that the bank warned the surety of the amount of the surety potential liability and risks involved such as explaining the nature of the document being signed together with the consequences. It is clear that the bank manager did not do so, but said that she would do well if she took up the offer. Also, Chandra's solicitor had failed to explain the risks involved to Debbie. The bank should have confirmed with Debbie whether she had been explained the nature of the transaction. Second, the bank should advise the surety to take independent legal advice, which was actually done by the manager. Thus, Debbie was able to set aside the security contract with the bank.
Now, I'll be talking about the contract between Chandra, Fuad, and the bank in the Malaysian position. Referring to Section 10 Subclause 1 and the Section 13 of the Contract Act 1950, Fuad and the bank agreement of using Fuad shares in the public bank company as security for Chandra's bank loan can be a contract as they agreed upon the same thing in the same sense with their free consent. Fuad now regrets entering this security contract with the bank. Referring to Section 14 Subclause B of the Contract Act 1950, consent is not free when it is caused by undue influence. Although parties agreed on the same thing in the same sense, so that there is consent within the meaning of Section 13 and an agreement will come into existence, the agreement is not a contract. The only way Fuad cannot rescind the contract is through Section 30 by proving that he was unduly influenced by Chandran and prove that the security contract with the bank is voidable. Using the case of Hong Kong and Shanghai, Banking Corporation, and Syarikat United Young Enterprise Sendirian Berhad and another, this case talks about how the first link of Section 16 Sub 1, domination of will was not proven. Relating this case to Fuad and Chandran, Chandran was a long-time friend with Fuad. From the facts, we can only say that there was a past relationship of trust and confidence, as Fuad has only often sought investment advice from Chandran, as he felt that Chandran was well-versed in business affairs. However, this does not show that Chandran was in a position to dominate Fuad's will. There is no special indication of them having any special relationship. Also, Chandran does not hold real or apparent authority over Fuad, nor does he stand in a fiduciary relationship with Fuad. In the case of Raghunatha Prasad and Sraju Prasad, it is mentioned that the unconscionableness of the bargain is not the first thing to be considered. The first thing to be considered is the relation of these parties. Were they such as to put one in a position to dominate the will of the other? We have proven that Chandran was not in a position to dominate the will of Fuad. The first link of Section 16 Clause 1 was not satisfied. Moving on to the next case, Ibrahim bin Musa and Bahari bin Nayan. This case is about how the second requirement of Section 16 Subclause 1 of unfair advantage was not proven. Relating the case to Fuad and Chandran, the dominant party here, Chandran, also cannot be said to have obtained an unfair advantage from the contract as he promised a share in the profits of the business to Fuad for the loan. This is not a significant disadvantage. The second limb of Section 16 Subclause 1 was also not satisfied. When talking about bargaining power, we can refer to the case RHB Bank, Berhad, and Single Fine, Sendirian Berhad and others. It was held in this case, Section 16 of the Act was concerned not with the lack of equality in a party's bargaining position, but rather in the dominance of the will of the bank over the defendants. There indeed was little time for the borrower to consider the terms of the bank settlement offer, but that did not mean that the bank had manipulated or forced the borrower's decision. The court was satisfied that the bank conduct in managing the relationship with the borrower was within normal business practices and didn't amount to undue influence. Relating this case to Fuad and Chandran's situation, Chandran was in a stronger bargaining position as he was more well-versed in business affairs, but that did not mean he dominated Fuad's will and forced him into the contract. Fuad has also gotten independent legal advice. Their situation can be said to have been just a normal business practice and did not amount to undue influence. Now, referring to the case of Pusaturai and Kadapachatya, Malaysian courts have traditionally assumed that the common law principles governing the doctrine of undue influence and the statutory rules incorporated in the Section 16 of Contract Acts 1950 are the same. The House of Lords relies on Pusaturai and Kadapachatya in National Westminster Bank and Morgan in support of the proposition that a transaction must be manifestly disadvantageous in order to raise the presumption of undue influence has helped strengthen the assumption. The facts of the case is the plaintiff alleged that his maternal uncles had influenced him to execute a deed of sale and sought to cancel the deed. It was held that no undue influence was proven. Since the sale was not a sale at an undervalue, it did not constitute to an unfair advantage to the influencer, and the sale was not unconscionable. Therefore, as the victim had not satisfied the requirement of Section 16 Subclause 3, the burden had not shifted to the influencer to disprove undue influence. Relating to this case, since we have already proven that Chandran and Fuad relationship does not satisfy both limbs of Section 16 Subclause 1, Chandran was not in a position to dominate Fuad's will, and the exchange of shares in Chandran business for Fuad shares in a public company as a security bank loan does not really constitute an unfair advantage to Fuad. Also, the bargain was not conscionable. Fuad does not satisfy the requirement of Section 16 Subclause 3. The burden does not shift to Chandran to prove that there was no undue influence. Thus, Fuad cannot rescind his contract with the bank.
Let me continue to talk about the contracts between Chandran, Fuad and the bank on the English position. These are the elements that constitutes actual undue influence set out by Lord Hobhouse in the Royal Bank of Scotland and H 2002. Actual undue influence requires a clear demonstration of actual pressure that equity deemed inappropriate yet not amounting to duress. Looking at the circumstances of the case of Fuad and Chandran, it is clear that it does not meet the criteria of actual undue influence. For instance, in the case of Williams and Bailey, 1866, plaintiff's sons forged plaintiff's signature to took out a loan. After the forgery was discovered, defendant's bankers met with plaintiff and informed him that they had the power to prosecute the son for the forgery. The plaintiff, under pressure during the meeting, agreed to enter into a mortgage to pay off his son's debt. It was held that the agreement was voidable because of actual undue influence exerted by the bank on the father.
Moving on, Lord Justice Slade in the case of BCCISL against Undue 1990 split Class 2 cases into two subdivisions. He labelled the well-established relationships such as parent-child, medical advisor-patient relationships in Class 2A cases where presumption of undue influence automatically applies. Lord Brown Wilkinson then incorporates Lord Justice Slade's concept and said state that even when there isn't a relationship fitting within classes 2A categories, the complainant may challenge the transaction by proving that they have reposed trust and confidence in relation to financial matter. In the case of Block Banks Limited against Bundy 1975, the customer had been a long-standing client of the bank and relied on the bank manager for all his financial advice for over the years. The manager was aware of the trust that the customer placed on him. However, it became evident that the transaction was not in the best interest of the customer. Hence, the relationship test that will lead to Class 2B depends on the prior dealings between the two parties, while also assessing the presence of evident trust and confidence. Applying all this to the case, Fad and Chandran have been friends for some time, and Fad often turned to Chandran for investment advice, demonstrating Fad's trust and confidence on Chandran in the past, particularly in financial matters. This particular scenario appears to fall under Class 2B presumed undue influence, which is based on a pre-existing trust and confidence relationship on financial matters. Since the requirement of pre-existing relationship is satisfied, there arises a rebuttable presumption of undue influence and forms to the second stage, where the court will scrutinize the transaction of whether there is anything that calls for an explanation. The burden of proof will shift to the dominant party to provide an explanation in order to rebut the presumption. As opposed to the case of actual undue influence, such as CIBC Mortgages Public Limited Company against Pitt 1994, where there is no need to show manifest disadvantage. For dominant party to rebut the presumption of presumed undue influence as stated by House of Law in Royal Bank's case, the greater the disadvantage for the vulnerable person, the more cogent must be the explanation before the presumption will be regarded as rebutted. In this context, the potential disadvantage to Ford seems insignificant due to the fact that Ford also stands to gain a share from Chandran's business profit. Hence, there is nothing about the transaction that calls for an explanation. Also, another typical way to challenge the presumption of undue influence is by demonstrating the transaction was free exercise of independent will by showing the victim received independent advice from a third party. While the bank may not possess actual knowledge of the scenario, constructive knowledge is likely since the security provider is Ford and the business belongs to Chandran. In the case of Hammond against Osborne, 2002, where a 72-year-old donor generously given substantial gift to his neighbor, Osborne, who had been taking care of him. The court concluded that Osborne failed to rebut the presumption of undue influence since the donor had not received any independent advice regarding the wisdom nor the consequences of his action. Thereby, the quote from a journal article, the presumption of undue influence by passivity Stapleton, to be sufficient for this purpose, the independent advice must at least be given with a knowledge of all relevant circumstances and must be such as competent and honest advice will give if acting solely in the interest of the donor. Barclay's guidelines for the bank are fully met, which can be seen when bank's in-house lawyer carefully explain the risks involved to Fund. Therefore, the contract between Fund and the bank is valid, so the presumption of undue influence is rebutted. As opposed to English position, Malaysian position cannot reach the conclusion of rebut by using victim received independent advice because there is no undue influence in the first place. In consideration of the points I have addressed, it is evident that there is not a significant difference in the conclusion reached in both English and Malaysian positions, which is Ford cannot avoid his security contract with Chandran nor the bank.
To conclude, Devi effectively established the presumption of undue influence, which Chandran had failed to refute the presumption. Additionally, the bank, being aware and had constructive notice of the transaction, did not take adequate measure when engaging with the surety, which was Devi. Consequently, Devi has the right to set aside the security agreement with the bank. Malaysian perspective, as outlining in Section 20, agreement is voidable in the position of the party whose consent has been caused by undue influence. Agreement is found to be void or contract become unenforceable. Any party who has gained an advantage from the contract is obliged to either return the advantage received or provide compensation. Section 66 of the applicable legislation expressly does not specifically mention the concept of voidable contract. In the case of Hong Yukin, it was stated under dictum that Section 66 will encompass voidable contract. In light of Section 66, it is required for both parties involved in a voidable contract due to receiving factor to either return any benefit received or provide compensation for such benefit. Therefore, Devi will be able to get back her house. Devi possesses the legal entitlement to declare the security agreement with the bank as a void on the ground of undue influence. Where Chandran and Ford agreement failed to meet the necessary condition for establishing undue influence. The fundamental disparity between Malaysian English law lies in the obligation to demonstrate an unfair advantage instead of undue influence. The relationship between Chandran and Ford failed to meet the criteria outlined in Section 16, subsection 1, as Chandran does not possess the power to dominate the will of Ford. An exchange of share between them does not provide both with any unfair advantage. The burden of does not shift to children for to demonstrate the absence of undue influence. Cannot void the security contract with the bank and is not able to rescind it.
That's all from us. Thank you.